Welcome, welcome everyone. I think we're ready to start. This is the parallel session hosted by George Washington University Competition and Innovation Lab. Today we're going to talk about the private enforcement of the Digital Market Act, something I really hope you're interested in, and for sure, if you're here, is something you would like to know more about. And we're really happy, indeed, in this panel to have three superstars, let's say so, of the Italian antitrust world.
So who is the fourth? It's not the superstar 1, 2, 3.
Three, but it's not of the Italian antitrust market. Yeah, it comes from the US, you know. And it will check on you. It will check on the European side, yeah. We're lucky to have, first of all, Professor Elisabetta Iossa. She's a commissioner at the Italian Antitrust Authority since 2022. Even though she's now into enforcement of antitrust law, her academic roots, I believe, are very much alive. She worked a lot as a professor at Tor Vergata on industrial organization, on antitrust as well, and on public-private partnerships. She did a lot of consultancies as well for the European Commission, for the World Bank, for the OECD, and she had a lot of positions abroad at University of West London, at Toulouse University, as well as Liège. So, I mean, she really managed to merge the academic profile with the policy making and enforcement one, and we're very glad to have you here. Thank you so much. We have also next Makis Asimakis Komnios. He's partner at White & Case, international law firm. He's a former commissioner at the Hellenic Competition Commission and a member of the board of such a commission. Well, his practice, as most of you might know, really spans a broad range of antitrust law. He had the fortune and the privilege to work on, over the last 2 decades, on the most important cases dealing with European competition law, and we're very lucky to have you here in this panel. You wrote extensively on the private enforcement of the Digital Market Act. You are truly expert on the topic, and indeed, you also have academic appointments at the Collège d'Europe, at the Panthéon-Assas University in Paris. So thank you again for being here. Last but not least, we have Professor Maria Teresa Maggiolino. She's a full professor in antitrust law at Bocconi University. Now, as I asked all the speakers to fully disclose potential conflicts of interest in their potential private practice, I'd like to have a full disclosure from my side as well, because, you know, Professor Maggiolino could have well become my boss in the early days when I got my PhD. In fact, I would have loved working with her, of course, but life instead took me into central banking. I work in the research center of the Italian Central Bank. I'm very glad to be there. But indeed, it's a delight to be here with Professor Maggiolino, first because I can interact with her, and second because I can call her a colleague, at least in this panel, without her to supervise my tenure track. So, lucky you. Okay, let's jump straight to the topic of today. Last but not least, again, we have Professor Aurélien Portuese. He's the founding director of the Competition Innovation Lab at George Washington University, and he will act as discussant of our speakers today. Now, let's jump to the topic of today, the private enforcement of the Digital Market Act. Makis, you wrote a tremendous article on the topic where you really explore the whole issue. And the main point you put forward in the piece is that Article 5, 6, and 7 of the Digital Market Act are sufficiently unconditional and precise to be invoked before national courts. And indeed, even if, of course, the European Commission is in charge of enforcing the Digital Market Act, this in itself should not exclude or rule out private enforcement. Well, I'd like to know a little bit more from your side what remedies at the moment might be available for private players to enforce the Digital Market Act without, of course, needing to change current national law or European national legal framework. You have 5 minutes to answer the question, and we will have 2 rounds of questions.
Yes. So, as you say, I mean, as I have expressed myself in writing, I believe that 5, 6, and 7, the substantive provisions of the DMA, would probably meet...
sorry, I'm so sorry to interrupt you. Just the full disclosure, very
full disclosure,
quickly. Yeah.
I'm a lawyer in Brussels, and I work in the with big tech companies. So, you know, you can visit my webpage and you will see. Certainly, I'm very partial when it comes to that, although my views are very objective. In fact, my belief that 5, 6, and 7 have direct effect goes against, so to say, the interests of companies that I might work for, right? So, but I'm speaking in my academic capacity here. So 5, 6, and 7, in my view, would probably meet the direct effect test of the Court of Justice. They are sufficiently precise and unconditional in that sense. You know, now, there is, of course, when we started with the DMA, the kind of the general view was that these provisions will be ex ante applicable, and they are self-executing, right? Self-executing. Self-executing is a different thing. What does self-executing mean? It means that, you know, nothing to do, everything is clear per se, you know, therefore, immediately in March 7, 2024, that's it, compliance period starts. As we all know from reality, nothing is self-executing, right? I mean, in reality, these provisions are not self-executing as such. I mean, you need to have a regulatory dialogue with the European Commission, that the regulatory dialogue is still going on and will be going on for the years to come and so on. And the devil lies in the detail. For example, there are recitals with cryptic references to specific concepts, you know, which are currently fleshed out in these discussions with the European Commission. But the fact that these rules are not self-executing in that sense doesn't mean that there is no direct effect, because the direct effect is a different type of concept based on the case law, etc. If we were to say that because of this complexity they're not directly effective, then Article 102 of the treaty should not be directly effective, right? I mean, therefore, you know, there's nothing different than Article 102 of the treaty when it comes to the provisions 5, 6, and 7 of the DMA. The DSA is a different species. There, I think there would be a number of provisions that may not be directly effective, legally speaking. That's a different story, the DSA, or indeed the AI Act. The AI Act also has certain provisions that may be directly effective, but others may not. But the DMA, I believe they are. Now, the question you're asking is about remedies. As you may know, there is one member state, Germany, which has introduced a specific chapter in the new German Competition Act, which applies to the DMA remedies. So there's a right to damages and so on. But let's leave Germany aside. I think that, you know, my, again, very personal view is that normally, like when you have a regulation, the very existence of a particular remedy should be a matter of EU law, in my view. It should not be a matter of member state law. So that there should be a right in damages, I mean, in my view, if you go to case law like Munoz, I mean, in the old days, etc., it means that the EU law should be giving you that right to damages. You don't need to go to the member states. Now, how you execute this right to damages, the procedural conditions, etc., this is up to each member state. That's the principle of national procedural autonomy. I have to say, however, the same I believed also for, not only for damages, but also for injunctions, which actually at this period, as we speak, are the most important remedy for DMA cases. Currently, it's not about damages. I mean, you know, we have had only 2 non-compliance decisions. Not a lot of time has passed since March 7th, 2024. I don't think the issue now is damages, it's really injunctions for the parties to go before the national courts and ask for preliminary or permanent injunctions. I would say the same for permanent injunctions, that this is a matter of EU law, that there has to be an injunction, but I have to say the case law there is really in a certain movement. I mean, there was a judgment on the 4th of September, a couple of weeks ago, which was about the GDPR, that's querying private bank, where, surprisingly, I have to say, for me, the Court of Justice did not say that there has to be an injunction as a matter of EU law, because we have a regulation there, but referred to the member states' laws, which is quite, I was surprised when I saw that. So I think, but still, of course, then they said as a matter of effective judicial protection, we need to, member states must provide for that, etc. So I think there the case law is in a state of flux. We will see how it develops over the next few years. But I would say that remedies as a matter of existence should be a matter of EU law, as a matter of exercise and procedural conditions, etc. It is up to the member states under the principle of national procedural autonomy to provide for such remedies, which are effective.
That's great. Thank you. Thank you, Marcus, for this overview. You really stayed on the time, so again, thank you again. Professor Jossa, Commissioner as well. Now, taking a step back and looking at the Italian scenario, if we consider the private enforcement of competition law from the perspective of the Italian antitrust agency, how is it developing? How has it developed so far from your view? And are there examples of follow-on actions or promising signs that we should keep in mind when considering the private enforcement of competition law?
Okay, thank you, Oscar. Thank you for the invitation. Disclosure, so I've been at the authority for 3.5 years. I have another 3.5 years to go. And before that, I was professor of economics and did no consultancy for any gatekeeper. I believe that disclosure is very important. At the authority, we're very careful about conflict of interest and are applying strict principles when it comes to monitoring trustee that refers to past engagement and future engagement. So with regards to private enforcement of the DMA, was this a good opportunity for me to think about things? A couple of considerations. As Asimaki said, I think it's quite clear that Article 5 to 7 are directly applicable, and individuals and companies can invoke them before the national court. I think it's particularly good that there is a provision in the DMA, which is Article 39, that establishes a principle of collaboration between the national courts and the Commission. And I think that is quite important for member states to specify national proceedings that apply to the DMA, as this can facilitate private enforcement. I recall the example of Germany, where such a specification has just been done, Section 3 of the GDWB Act. And apparently, this has already led to a first standalone case has been decided last August, and that relates to Article 5.8 of the DMA on the ban on tying, and in particular on tying between Gmail and Android services. So this is important because from the perspective of a public enforcement, I think private enforcement plays a very important and complementary role to public enforcement. And it does so both through follow-on actions, which of course help to increase deterrence, and also give incentive for complainants to come to us, knowing that after our decision there may be a follow-on action. But I think it's also very important for private enforcement to fill gaps. And therefore, I think standalone cases are extremely important. So in this regard, I tend to say that public and private enforcement should act both as complements, but in both dimensions, not just pushing for full-on action, but also for standalone action. And in that regard, I think the German example is a good one. There is a risk that has been debated a lot about the fact that standalone actions may cause some fragmentation. And I understand that concern, but at the same time, I think that kind of concern arises also with private enforcement of Article 101 and 102. And in fact, in a sense, the risk of fragmentation is even lower with the DMA, given that these are ex ante provisions clearly specified. So I expect national courts to intervene with consistent decisions, as the ones of the Commission. And I think the importance of the digital sector and the characteristics of the digital sectors, which as economists we know very well, related to the network effects, the economies of scope, the indirect network effects are such that things change at an amazing pace. And sometimes it might be extremely difficult to intervene effectively after a few years. So the urgency of decision, the fact that decisions are timely, is a priority. And that's why I think we need resources and forces from the Commission, of course, which is in the first line and is doing a wonderful job, from the national authorities that will be the first point of contact for national companies and they can come forward, and for the national courts that are a pillar of our institutions. So in that regard, the complementarity between the three institutions to me is fundamental, and we can well work in order to ensure minimization of the risk of fragmentation in order to maximize enforcement. And in that regard, let me say that the authority is, of course, ready to receive complaints. We have also a very important tool, which is the whistleblower tool, that allow companies, individuals to come to us and interact to us by simply sending an email without their identity, if they want, ever being revealed. This is a tool that is extremely important in my view when it comes to digital enforcement, because what we are seeing is the fear of retaliation by companies. And of course, that fear of retaliation is there because these companies act as gatekeepers. And if the access to the gatekeeper is in any way compromised by retaliation, the company may sort of face very strong consequences. So the main message is really this complementarity. We should work on, increasing and enhancing cooperation. But I think the role for private enforcement is there and is extremely important.
Thank you so much, Professor Josse. Indeed, that's fascinating. You actually described a sort of triangle of private enforcement of the DMA between national court and authorities, the European Commission. I mean, that's really fascinating, and it might be extremely beneficial indeed for the internal market. Now, moving to Professor Maggiolino, I mean, we already touched many topics, but indeed, regulatory dialogue has always been key in the talking of the European Commission in order to make the Digital Market Act effective towards gatekeepers. And indeed, do you see, as many already hypothesized, a sort of risks of undermining such regulatory dialogue between the European Commission and big techs if we let national authorities to act on standalone cases, for instance?
National courts.
National courts, of course. Yeah.
Well, in the literature, there are many people talking about this risk of preemption. This risk could happen if national courts will interpret Article 5 and 7 before the Commission did, or whether they would intervene with a remedy before the Commission did. And this, at a first glance, could undermine the central role of the Commission as the only one regulator engaged in this dialogue, ongoing dialogue with the gatekeepers. Now, in addition, the possibility for national courts to proceed with standalone cases could create parallel proceedings, increasing the cost for gatekeepers and also increasing the cost of conflicts among the many decisions of the national courts. And this clearly would still increase the risk of undermining the central role of the Commission and so creating fragmentation that the DMA wanted to fight. I would say that these risks depends on at least 4 elements. First of all, the clarity of each provision of the DMA. I don't think, as probably Makis was saying, all of them from 5 to 7 are equally clear, equally immediately applicable. And so probably there will be room for differences among national courts. If the dialogue with the Commission, and if the dialogue among national courts and national authorities is not very strong. Then I would say that a big difference would result from the kind of remedies courts will take. One thing is issuing a cease and desist order, a prohibition decision. Let's stop doing this and that, as the court in Germany did in the case Commissioner Professor Jossa said. Another thing is imposing a positive behavior, taking actions towards business users or doing something for the sake of competition. Now, in that case, we could have different national courts imposing different positive remedies. And this, again, would increase the cost of the enforcement. And then the territorial scope. There could be cases where the territorial scope is the overall EU, and cases where the behavior regards just the national market. And so I would say that the risk of fragmentation will depend also on this, and obviously on the ability of the Commission to be as quick as possible in acting and interacting with national courts. As Commissioner Professor Jossa said, Article 39 will play a very significant role in this, but it means the national judges should use it. So stay on the proceeding, waiting for the Commission to take a decision, collaborating with the Commission, and also try to adopt remedies that are not very intrusive as they could be, or also trying to create uniformity among all of them. Maybe what he proposed in his papers that courts at least in the very first years of the enforcement of the DMA could be refrained from doing standalone action, could be incentivized to do only follow-on action, could have been a good solution to limit in a significant way the risk of preemption, the risk of fragmentation.
Thank you, Professor Maggiolino. Indeed, very sharp and on point, the importance of...
Sorry, I had to disclose.
Oh, right.
Okay, sorry.
My bad.
I apologize for that. I am a professor. I do not work for big techs. I do work for some bad guys, but they belong to the old economies, pharmaceutical companies, oil companies, so nothing related to the DMA.
My bad.
Tech is bad, I mean, for sure. You say, don't work for big tech, but I do work with some bad guys.
Well, maybe they are not willing to pay for me. That's the story.
Not indeed, I mean, the importance of coordination and speed of such a coordination between national courts and the European Commission is going to be key. Now, before moving to the second round of questions, Aurélien, do you have any comments on the points the speakers today have touched upon? I mean,
yeah, sure. So, in addition to my faculty position, I'm affiliated with Campus Lexicon, who's working for and against gatekeepers generally. I think I want to say two things for the private enforcement and to react to what has been said. I think we need private enforcement of the DMA, and we don't take it seriously. We definitely don't take it seriously. We don't want it. We didn't design the DMA for that, and we do everything we can not to have the private enforcement. Just, I think it starts from, the Article 5, 6, 7 are or direct effect. We have Article 8, which reversed the burden of proof where the gatekeepers have to show that they're compliant. So that will lower the evidentiary thresholds when you sue in court. So that would facilitate normally the work in court, and that will lead to private enforcement. But the only provision that you have for the private enforcement of the DMA in the DMA is Article 42 when it comes to representative action directives. And this Article 42 is just tells you everything that you need to know about how the European Commission doesn't take private enforcement in general seriously. Because this directive, first, has not been implemented by most states. Of course, Germany is a good example, is a good student, and I think the Netherlands as well is moving very fast, but most states haven't transposed this directive. So already we know there's no such a thing as a true European class actions for antitrust. Second thing is that directive only applies for qualified entities suing on behalf of consumers defined as natural people. So it's not about companies, and it's not about individual companies. It's a group of collective consumers. Like it's very much like a consumer protection action. It's not an antitrust actions. So we don't take private action seriously. There's no will to have one company suing another company on behalf of that company. That's it. We have these class actions for consumers, and we do everything we can to prevent this private enforcement. It's by design in the DMA not to have private enforcement. So we can be surprised, like, why don't we have private enforcement? Well, the answer is because the European Commission doesn't want it, and member states don't want it. They don't transpose directives that could help. The European Commission doesn't design regulations in order to have private enforcement. And why so? Well, because we believe in Europe that the European Commission has the monopoly of enforcement, the monopoly of competition compliance. And that's not true. I mean, in the US, most of the time we talk about enforcers, right? Antitrust enforcers. In Europe, it's about regulators. We regulate competition. And we never truly think about enforcing in a very diffuse way. It doesn't have to be authorities. It can be litigants, right? And that tells you another thing, which is we don't have a European common law of antitrust. You don't have a way of going to court, national court, with extraterritorial effect. We are, of course, impeded within national courts. That leads to the fragmentations. So we need a complete rethink of what it is to have a European antitrust, what it is for people to go to national court with extraterritorial effect, and how can we empower them? And so it's no surprise that we don't have private enforcement, because we do try to make some very marginal, tiny little change of something that is designed not to work, that is the private enforcement of the DMA.
Yes, of course. As you can understand, it comes from the US at the moment, where private enforcement is very much a big deal over there. And thank you so much, Aurélien, for your reflections. And now, moving to the second round of questions, Makis, again, talking about private enforcement, we should also think about what can go wrong, right? I mean, and potential conflicts between national decisions by courts and the, you know, and the strategy of the European Commission, you know, might emerge from time to time. And do you see that some changes of the current legal frameworks might be needed in order to address such conflicts?
I would first like to react a bit about what I've heard so far and then go straight to the point. Now, on Elisabetta's point about fragmentation, I mean, one point where I disagree is where you say, well, fragmentation, competition law, you know, we have never had this issue, you know, there's a difference between the competition rules and the DMA rules. The difference is, if you take a historical approach, when did we start really enhancing private enforcement of the competition rules? It started in reality in the early 2000s, 40 years after the rules were in existence, and during this period, the European Commission obviously had produced a lot of decisions. We had a lot of decisional practice from the European Commission, and we had lots of case law from the Court of Justice and from other courts. At that time, the period was mature to take a step further and, let's say, open it up to private enforcement. Now, I'm not suggesting that we should wait 40 years. I was not suggesting, I had written an article back in 2021 or 22, I can't remember, where I was suggesting the lege ferenda to restrict the DMA private enforcement for follow-on claims. I'm not suggesting that we should wait 40 years before we open it up entirely. I was suggesting essentially to wait a bit for the first decisional practice of the European Commission to take effect, to have some first decisions, to see how these rules work, to have some first case law, and then at some point, and I would open it up to the national courts to start dealing with that. There's a difference because, so there is a first difference, the historical element which I just mentioned. So also for competition rules, we did wait a bit to open it up to private enforcement. There's another difference, which is because of their very nature, these practices are global. We are talking about practices of 5, 6 companies essentially, which are global, and therefore fragmentation risks are very much more problematic here, because you can't have, for example, a court in Germany ordering something only for Germany or only inter partes, essentially, between the gatekeeper and that particular claimant. The practices here are global, and you have not just that particular claimant, but you have lots of other claimants. There's a principle of non-discrimination. Should that claimant be treated differently than other kind of app developers, so to say? So, you know, it's very different, I would say. Now, in the end, the legislator decided not to restrict it to follow on, but to open it up for standalone. And now I come to the issue, I mean, what are the main problems today that we see? What we see is, I mean, first of all, Article 39 refers to some mechanisms to deal with the problem. One particular mechanism is to say if there is an initiation of proceedings by the European Commission under the DMA rules, and the national court is deciding on a topic which is similar or the same, etc., the national court should stay proceedings. Okay, initiation of proceedings. But what about all these other cases, which is the vast majority of cases, where the Commission continues the regulatory dialogue without having opened proceedings? And we know, I can tell you very well, that the fact that the Commission has not opened proceedings doesn't mean that everything is perfect.
Which might be 80% of cases.
Yeah, I mean, it's like 80% of the case, as you say. So what about those cases? Article 39, formally speaking, cannot work there. Now, obviously, I would go before the national court and I would say, look, yes, okay, as a matter of Article 39, you're not bound to stay, but I think in this case, based on Article 4, paragraph 3 of the Treaty of the European Union, the obligation to show respect to community institutions, etc., I would stay. The prudent way would be to stay for a reasonable period. I wouldn't stay, for 10 years, right? I mean, I would stay for a reasonable period. and wait to see what the Commission will do. Or you can try to ask the Commission, you can send questions to the European Commission and so on. So the first issue is what happens with those cases where we don't have initiation of proceedings. Another problem I see is that what we have in most of these cases now is interim relief applications. That's the problem. And in interim relief applications, the courts have to decide quickly. A stay in interim injunction proceedings is very difficult. The court will never grant that. I mean, you can't be serious. So what I've seen now is the national court sometimes is ready to take the most crazy kind of measures you can imagine as an interim relief order, essentially. And at the same time, it's very difficult to tell the national court to stay proceedings because this is an interim relief proceeding. So there, I mean, what do you do? And, you know, preliminary reference to the European Court of Justice, forget about it. This is interim relief proceedings. Yes, formally speaking, it is possible, but it will never happen. So this is, again, another issue. And the only way out, I think, is, in these cases, for the European Commission to try and play a bit of a more kind of regulating role. I understand, because of the fact that they don't have a lot of resources, this is not ideal for them to try to be like the big dad for all kinds of national courts from Poland to Portugal, essentially. But this is where we have an issue. And that's why I think my original proposal to restrict it to follow on would have been better to follow. But anyway, I stop here.
Thank you, Makis, for enlightening us on these. And now, moving to Commissioner Josa, indeed, we are hosted today by Lear, which is an economic consultancy firm. I see Paolo, and thank you so much for having us. And indeed, you are also a top-notch economist in industrial organization, and the role of economic analysis is just key when it comes to antitrust enforcement and competition policy more generally. So on this point, I really like to know your view about the potential of the economic analysis offered by antitrust authorities when it comes to private enforcement. I mean, is there a role also changing things in the future to make sure that such public service offered by antitrust authority to the market can help to overcome potential fragmentation at the level of the internal market and to help operators willing to engage with private enforcement?
Okay, so let me first say that economics is about incentives. That's the very first thing. And there is a very interesting and healthy mechanism when it comes to the interaction, again, between public-private enforcement. And that is, as I mentioned before, the fact that more enforcement creates greater incentives for follow-on damage actions, or in general for damage actions. And that creates greater incentives for reporting non-compliance to national authorities working side to side with the Commission or to the Commission. And this in turn helps ensure that the DMA achieves its primary objective, which is not sanctioning firms, but obtaining compliance. And if enforcement is sufficiently effective, then economists will say compliance becomes on the equilibrium path, meaning that we are not going to see non-compliance decisions and that the digital sector works is contestable and fair. So that is where I'm coming from. Then, of course, getting back to what Maria Teresa and Asimaki said, I understand the risk of fragmentation, but my primary concern is the risk of under-enforcement. And therefore, I think we should always work pooling resources, working side to side, through collaboration. The mechanisms are there. The Article 39 creates the dialogue between national courts and the Commission, Our authority was the first, if I'm not mistaken, to approve national proceedings for the collaboration between the authority and the Commission. And again, this is because we truly believe that enforcement is about collaboration and pulling together resources. The Commission published a study a kind of a year ago where it reported that 87% of all the infringement decisions in the last 10 years or so come from national competition authorities. It's just a matter of fact that we need resources, and the role of national competition authorities, as much as the role of the courts, is fundamental. Of course, the leading role is the Commission, and I believe is doing a great job. Back to economic thinking. So the DMA is per se, we know that, good. And there is no efficiency defense. Yet, I think economists can play a very important role. First of all, in sort of, I think, explaining to firms about the importance of coming forward, and perhaps even using whistleblower tools if they fear retaliation. But they also play a very important role because what we see more and more in the digital sector is that whenever you have a role, an ex ante role, or you have an infringement decision saying this cannot be done, companies are very quick to respond, trying to find circumvention strategies to achieve the same objective. And this is because if you look at the digital sector, when you understand a business model, the business model of the firm, and there are various different business models, you can understand what incentives that business model create and what kind of infringement are just behind the corner because they are created by the incentives. In that regard, I think economists have a very important role to play. I recall, for example, you may look at this, a decision by the Italian authority on booking. It's not an infringement decision, it's a commitment decision, but it's a very interesting one. There is a lot of economic thinking there about these partner preferred programs. Look at the incentives that those programs may create and what kind of implications these kind of programs, which are spreading around, may generate. So I think the role is there, and again, I always think that we are a community. We are not, in the long term, we all benefit from stronger and better enforcement. And therefore, I think we should all be very proactive when it comes to intervening in the digital sector.
Yes, indeed, we might call them the positive externalities of strong enforcement. And I mean, the role of economists in providing an optimal incentive framework is really key to help the legal side of the antitrust world. And on this, Professor Maggiolino, we covered many obstacles that might hinder private enforcement of the DMA, both from a legal, cultural, as Aureliana mentioned, an economic perspective. I think, did we miss something on this issue, or which one do you think is going to be most serious, and we have to take it first?
Well, let's try to make a summary. On the one hand, applying the DMA in courts would be easier than applying Article 102 because of what we know, because we will not be supposed to define a relevant market, find out the dominant position, find out the effects, analyze the defenses, and that's fine. On the other hand, in damages action, what you have to prove are damages in order to get the redress. And damages, and in order to prove damages, you have to create a counterfactual in some markets, such as digital markets, which are very complex. Understanding how a business user or a user has been harmed by self-preferencing, means understanding how the world would have been without self-preferencing. Now, we can do that, but one thing is having the economists of the national competition authorities of the commissions doing that for the sake of the public, and then relying on those studies, on that knowledge to bring an action. Another thing is hiring an economist doing for you in that specific case. That's expensive. And so I fear, I don't know what will happen, I fear that this could be a serious obstacle for those who will bring actions against gatekeepers, because they enjoy strong asymmetries of information on their side. And so to, let's say, open up the black boxes, understand how the business models are, and then ask for damages, creating counterfactuals could be very cumbersome for the plaintiffs, especially in those member states where collective redress is not available for business users. There are many member states where collective redress is available for consumers. But before getting to that, maybe we could have single competitors of the big companies trying to get redress, but they cannot rely on collective actions. So, I'm not pessimistic as a person, I'm never pessimistic. I think that in a while we will have a strong industry for the private enforcement of the DMA. But we will need to overcome some obstacles, and I would really appreciate the Commission to go first and to put down the barriers that now private plaintiffs may find.
That's tremendous notations from your side, and again, full disclosure, she told me she was not an expert on private enforcement, but the points you raised are actually extremely relevant, and these...
Good child, I study.
Well done, well done. Again, I could have been a good fellow of yours. Now, moving to Aurélien, you have remarks on this second round of answers from our speakers, and we're moving towards the end of our panel, unfortunately, so help us to wrap up as well.
So just going back to just a step back to the DMA, the essence of the DMA. The point that we've heard for years and years and years is that we need timely interventions. We need fast interventions. And I can't understand why, if we need timely interventions, why we don't ask anybody to help for this kind of enforcement. How can the European Commissions or member states not use private litigants' capabilities, leverage that in order for these timely interventions to take place? So there's a fundamental contradictions in wanting timely interventions and having centralizations with limited resources at the European Commissions. If you want timely interventions, it should be a dispersed, diffuse enforcement. And so there's a fundamental contradictions between the essence of the DMA and the central public enforcement that is in the essence of the DMA. The second point that I wanted to make is that reveals something that I've said earlier, but that reveals also a strong skepticism toward the courts. Like the idea that the European Commission, the authorities, of the monopoly of science and knowledge, and the courts need to be looked at very skeptically. And I think that's also very negative. I think we need to trust the courts more. The point of having private enforcement, the benefit of a private enforcement is in court, is a better adherence to the due process. Because the DMA is fundamentally in this regulatory dialogue where there's nothing more opaque than regulatory dialogue. Who knows what's going on now with the gatekeepers? Who commit to what, when, how? There's no such a thing. When you go to court, you are entitled to due process, to transparency, to public information. And I think there's a fundamental difference between a public enforcement that leads to regulatory dialogues where the gatekeepers don't have sometimes the due process they deserve, and also the public don't have the transparency they deserve, and the private enforcement that secure fundamental rights and due process in court. So it's not public enforcement and private enforcement as if they were interchangeable. It's fundamental difference in nature. It's not as you enforce publicly or privately, it's interchangeable. So that's my few closing remarks.
Thank you, Aurélien. I think we are approaching the lunch break, so I'm afraid there will not be time to, share views with the audience, but we still have 3 minutes, to give to our speakers if they really want to share other final comments very briefly on the issues we covered today.
Thank you. I mean, let's leave the DMA aside. Aurélien raises a very important question. It's about the role of the courts, the role of the regulators, essentially, and all that. I mean, in Europe, we have a different model, Aurélien. We are not really a litigation culture. We don't have a litigation culture in Europe. I mean, we have totally different model than in the US. In the US, you have private enforcement. The litigants are the private attorney generals. We don't have that in Europe. Now, 20 years ago, 25 and 30 years ago, in fact, I did my PhD on private enforcement. In fact, I'm considered to be one of the fathers of private enforcement in Europe, as Gabriela will know. But over the years, now that I've seen things, my mind has changed a bit. I think that private enforcement, yes, as a matter of law, it should be there, as a matter of effective judicial protection. Victims should always be possible to go to court, but for me now, I don't think that private enforcement is the answer to all the ills of the world, because it entails a lot of misallocation of resources. Look at how all these proceedings have evolved over the years. I mean, small Mr. Manfredi for 500 euros going to court, and then you have the courts in the UK. Every year there's a new important judgment on this jurisdictional issue, and then there's another one on this fringe issue, etc., which with costs of millions of pounds, and so on and so on. So for me, I no longer believe that private enforcement in the US sense is the way to go in Europe. I think the system works. Complementary systems between public enforcement, with strong public enforcement, and private enforcement is what we should have, but I wouldn't go as far as the Americans, to be clear.
Thank you, Makis, for being so frank. And Commissioner Llosa, you have a final remark as well?
Yes, so let me just stress again the complementarity role in both horizontal and vertical dimensions, so both on follow-on and standalone actions to fill gaps. I think the priority is really to have timely responses, and in that regard, joint forces is very important. From our part, of course, as public enforcers, we are absolutely ready. So we have these national provisions that allow us to run inspections. We can work on joint teams, and we have the expertise, as you know, that the authority has a long stream of cases that have been concluded successfully. The last one is the Court of First Instance confirming fully the decision of the authority on Amazon MFA, only reducing the sanction. So I think the role of national authorities is very important, and we are extremely eager and proud to work side to side with the Commission. Thank you.
Thank you. Aurélien is good, Maria Teresa is good as well. So, I mean, I'm very happy about this panel. I really want to thank George Washington University Competition Innovation Lab for having hosted such a panel. As a senior fellow of the lab, I'm really proud of that. And indeed, I mean, this is one of the few panels I witnessed where basically the number of people in the audience just increased over time. So I think we did well, and please all join me in a final round of applause to our speakers. Thank you so much.